Go.
The
Schoolhouse
Gate, Chapter 5.
Overview. Court cases. Brown versus Board of Education. Parents involved versus Seattle School District. Swan versus Charlotte Mecklenburg Board of Education. Keys versus School District Number 1. Milliken versus Bradley. Equal protection. Racial segregation and the enduring battle over Brown versus Board of Education. Brown versus Board of Education. Background information. Brown versus Board was a name given to 5 separate cases. These cases were Brown versus Board of Education of Topeka, Briggs versus Elliott, Davis versus Board of Education of Prince Edward County, VA, Boiling versus Sharp, and Gebhardt versus Ethel. While the facts of each cases are different, the main issue in each was the constitutionality of state-sponsored segregation in public schools. Brown versus Board of Education was a landmark 1954 Supreme Court cases which the justices ruled anonymously that racial segregation of children in public schools was unconstitutional. Brown versus Board was one of the cornerstones of the civil rights movement. This movement helped establish the precedent that separate but equal education and other services were not, in fact, equal. Parents involved versus Seattle School District. Background information. The Seattle School District allowed students to apply to any high school in the district. Certain schools often had too many students apply, so they used the system to choose which students would go to which schools. A tiebreaker to choose who would go to the popular school, and a tiebreaker was a racial factor intended to maintain racial diversity. A nonprofit group, Parents Involved in Community Schools, sued the district, arguing that the racial tiebreaker violated the Equal Protections Clause of the 14th Amendment as well as the Civil Rights Act of 1964 and Washington state law. By a 5-4 vote, the court applied a strictly scrutiny framework that found the district's racial tiebreaker plan unconstitutional under the Equal Protection Clause of the 14th Amendment.
Swan versus Charlotte Mecklenburg School District. Background information. 17 years after the Supreme Court ruled on Brown and declared segregated schools were unconstitutional, there was still immense resistance against integrating public schools. Many schools across the South attempted to find ways to undermine the decision until the court case of Swan. Facts of the case. In Charlotte, North Carolina, Vera and Darius, the parents of a 6-year-old boy, sued the Charlotte Mecklenburg School District on behalf of the NAACP to allow their child to attend Serviceville Elementary. In 1965, Swan versus Charlotte Mecklenburg was decided on in favor of Charlotte Mecklenburg. Because there was no requirement in the Constitution to act purposely to increase racial mixing, the Swan case was filed again. The court rejected the board's plan in favor of Dr. John Finger's plan. The case was appealed and heard at the U.S. Court of Appeals for the Fourth Circuit. The final opinion affirmed McMillan's order, which consisted of a plan rezoning neighborhoods into pie-shaped wedges where African Americans living in the center of Charlotte will be divided up and distributed to outlying formerly white high schools. When the court mandated that busing should occur to desegregate the schools, they also noted that one day when the school system was thought to be unitary, busing would end and the school board would be able to come up with a new plan which would best suit the education of students in Charlotte Mecklenburg. This decision from the case led to the widespread use of busing to end segregation by federal judges in the South. Keyes versus School District Number 1. Background knowledge. There had been evidence of de facto practices that exist in reality but are not recognized by laws. Segregation in Denver, Colorado School District. By the school district's use of attendance zones, optional zones, and mobile classrooms units, they maintained a de facto segregation. Facts of the case. In April 1969, a group of parents brought suit against the Denver School District, alleging that the entirety of the Denver school system was guilty of racial segregation and was therefore in violation of the 14th Amendment right to equal protection of the laws. The school district's counterclaim defended that even if that was true, the Denver School District was guilty of racial segregation. That did not mean that all of the school districts in Denver area was likely guilty. Decision. The courts ruled against the Denver School District, ruling that there was significant evidence of segregation in the Denver School District to implicate the entire Denver school system. Milliken versus Bradley. Background information. Background knowledge. By the 70s, many urban school districts had supermajorities, making educational segregation widespread. Racial barriers were disguised in informal practices that opposed African Americans living in the suburbs. Facts of the case. On August 18, 1970, the NAACP filed suit charging the Detroit, Michigan state officials, including Governor William Milliken. The NAACP argued though schools were not racially segregated, the city of Detroit and the state has enacted policies to increase racial segregation in school, drawing relations between redlining practices and educational segregation. The NAACP's motion was denied by the district courts, and the case was then sent to the Sixth Circuit Court of Appeals and affirmed the segregation that had been practiced by the school district, but withheld judgment on the relationship of housing segregation with education. Decision. The Supreme Court overturned the lower courts, asserting that school districts are not obligated to desegregate unless it has been proven that the lines were drawn with racist intent, concluding arbitrary lines drawn by state agencies which produce segregated districts is legal.
In 1952, Brown versus Board of Education. 1971, Swan versus Charlotte McLugbert. 1973, Keyes versus School. 1974, Milliken versus Bradley. 2007, Parents Involved versus Seattle. Thank you.
Thank you.